Donald Trump reportedly erupted in court with such intensity that the judge warned she could eject him from his own trial. The trigger was the day's most damaging testimony. His former bodyman, an aide who spent 4 years by Trump's side almost constantly, told the jury under oath that Trump personally directed the destruction of documents while investigators were actively seeking them. The witness described Trump feeding papers into a fireplace at Mar-a-Lago, saying, "They'll never get these." This wasn't the account of a distant acquaintance, political rival, or someone nursing a grudge. It came from a trusted insider, the person who carried Trump's Diet Cokes, handled his phone, and witnessed private moments few others ever saw. Initially, this aide was seen as loyal, dependable, and unlikely to break ranks. But when his own criminal exposure became real, the calculation shifted. Facing the prospect of federal prison, he chose cooperation over incarceration. Prosecutors had been meeting with him for months, and now the jury heard his account in open court. The significance isn't just that someone spoke against Trump, it's that the alleged destruction of evidence is reported by an eyewitness with extraordinary access, someone whose loyalty Trump had every reason to take for granted. Trump's reaction in court matters because it signals how threatening this testimony is to the defense. To understand why, consider the case's structure. For weeks, prosecutors methodically introduced documents, phone records, and witness testimony to show classified materials were improperly stored at Mar-a-Lago. The defense leaned on a familiar line. Trump relied on lawyers, any retention was accidental, and the prosecution was politically motivated. Essentially, it was shaping up as a credibility contest, government narrative versus Trump's narrative. Then, this witness took the stand, and the tone reportedly shifted immediately. Court reporters noted the former body man entering through a side door, avoiding eye contact with Trump. Observers said Trump leaned forward in his chair, visibly tense, shaking his head before the witness spoke. This moment unfolded because the witness, a cooperating defendant who pleaded guilty to obstruction, decided protecting Trump wasn't worth sacrificing his own freedom. Prosecutors offered a deal: full cooperation and truthful testimony for a substantially reduced sentence. He accepted. Cooperating witnesses are common in federal cases, but what's rare is the closeness of this cooperator to the defendant, someone with day-to-day access, repeated direct observations, and intimate knowledge of private behavior. That's what makes this testimony stand out. On the stand, the witness laid out the scope of his relationship with Trump: 4 years of near-constant proximity, calls with world leaders, travel on Air Force One, access to sensitive areas of the White House, and later Mar-a-Lago. He estimated he spent more time with Trump than almost anyone, possibly second only to Melania. Prosecutors then focused on the critical period, the summer of 2022, after the National Archives requested the return of presidential records. The witness described conversations where Trump expressed anger and indicated certain materials would not be returned. Then came the core allegation. Multiple reporters said the witness testified that, on at least 3 occasions, he saw Trump personally destroy documents. One incident was described in vivid detail: Trump standing in front of a fireplace at Mar-a-Lago, feeding papers into the flames while complaining about the bastards trying to get him. The value for prosecutors is clear. This isn't a story of a subordinate following ambiguous instructions. It's an eyewitness account placing the alleged destruction directly in Trump's hands. That shifts the case entirely. A defense strategy blaming lawyers or staff becomes far harder to sustain when the defendant is personally accused. Claims of inadvertent retention weaken when deliberate destruction is in play. This fracture of loyalty under legal pressure is familiar. Intense allegiance until personal consequences loom, then cooperation becomes the rational choice. Michael Cohen once portrayed himself as the ultimate loyalist, a fixer willing to take a bullet for Trump, until federal charges forced him to choose. Alan Weisselberg, the longtime CFO of the Trump Organization, who knew the company's internal workings better than almost anyone, also chose a plea deal and cooperation over maximum legal exposure. Even attorneys who once defended Trump aggressively have found themselves compelled to provide information when their own licenses or liberty were on the line. Mark Meadows, Trump's final chief of staff, has also been widely reported as someone investigators pursued, with cooperation repeatedly emerging as the safer path under legal jeopardy. The point isn't that every witness is flawless. The point is that the gravitational pull of self-preservation is powerful, and when it draws in people closest to the defendant, it can be devastating in front of a jury. That pattern of loyalty collapsing under pressure now includes Trump's former body man, a figure who, like others before him, discovered that Trump's protection has limits. Loyalty remains intense until it demands personal sacrifice. At that moment, many of Trump's closest associates conclude they are on their own. Claims of inadvertent retention weaken when deliberate destruction is in play. This fracture of loyalty under legal pressure is familiar. Intense allegiance until personal consequences loom, then cooperation becomes the rational choice. Michael Cohen once portrayed himself as the ultimate loyalist, a fixer willing to take a bullet for Trump, until federal charges forced him to choose between loyalty and survival. Alan Weisselberg, the longtime CFO of the Trump Organization, who knew the company's internal workings better than almost anyone, also chose a plea deal in cooperation over maximum legal exposure. Even attorneys who once defended Trump aggressively have found themselves compelled to provide information when their own licenses or liberty were on the line. Mark Meadows, Trump's final chief of staff, has also been widely reported as someone investigators pursued, with cooperation repeatedly emerging as the safer path under legal jeopardy. The point isn't that every witness is flawless. The point is that the gravitational pull of self-preservation is powerful, and when it draws in people closest to the defendant, it can be devastating in front of a jury. That pattern of loyalty collapsing under pressure now includes Trump's former body man, a figure who, like others before him, discovered that Trump's protection has limits. Loyalty remains intense until it demands personal sacrifice. At that moment, many of Trump's closest associates conclude they are on their own. That context matters for what happened next in the courtroom. Trump's conduct during the testimony became so disruptive that the judge warned she could remove him from the trial entirely. According to multiple reporters, his reactions escalated as the witness spoke, starting with visible head shaking, then audible muttering that drew warnings from the bench. When the witness described the fireplace incident, Trump reportedly shouted loud enough for the jury to hear, "He's a liar, a complete liar." That crossed a line. The judge immediately called a sidebar and issued a clear warning. Any further outbursts would result in his removal. While defendants have the right to attend their trials, that right can be forfeited through disruptive behavior. Observers noted Trump appeared to struggle physically to restrain himself afterward. His face was flushed. Attorneys passed him notes urging calm, and at one point he crumpled paper loudly enough to draw jurors' attention. Even without another verbal eruption, the message was clear. Jurors watch defendants closely, and visible anger during damaging testimony rarely helps. Legal analysts note that jurors often interpret such reactions as emotional responses to truth rather than fabrication. This was also the moment the defense's carefully constructed narrative began to unravel. Trump's legal team had worked to portray him as a reasonable figure caught up in a politically motivated prosecution, a narrative that depends heavily on demeanor. A defendant who appears unable to control himself when confronted with adverse evidence undermines his own credibility in real time. Then came cross-examination, which, rather than containing the damage, compounded it. Trump's attorney tried to paint the witness as a liar motivated by leniency. Then came cross-examination, which, rather than containing the damage, compounded it. Trump's attorney tried to paint the witness as a liar motivated by leniency. The witness, however, openly acknowledged his plea deal and explained that full, truthful cooperation was required. Any falsehood would void the agreement and restore full criminal exposure. More importantly, when the defense suggested the fireplace incident was fabricated, the witness produced a critical detail: contemporaneous notes. He testified that he had begun documenting troubling incidents in 2022 when he realized something was seriously wrong. Prosecutors argued that those notes were corroborated by other evidence already introduced, including analysis of fireplace ash and records showing documents that were logged but never recovered. That left the defense with narrowing options. They could continue attacking the credibility of a longtime insider with years of proximity, detailed recollections, and documentary support. But that risks alienating jurors who might find the witness measured, consistent, and credible. Alternatively, they could attempt to reframe the conduct itself, claiming, for instance, that Trump destroyed copies or unclassified material. But that theory collides with the broader evidence and asks the jury to believe a former president happened to burn documents during an active federal investigation for benign reasons. It also demands jurors suspend common sense. The core problem for the defense is that nearly every anticipated line of attack has already been addressed. The testimony was specific, consistent, and supported by physical and documentary evidence. Explaining it away requires the jury to make leaps that most people are unwilling to make in a criminal trial. The ripple effects have extended well beyond the courtroom. Within Trump's political orbit, the testimony has sparked anxiety and recalculation. If someone with total access, someone previously trusted implicitly, chooses to testify this way, other former insiders may reevaluate their own legal exposure. For Trump's supporters, the testimony presents a separate challenge. Claims of prosecutorial persecution are harder to sustain when the account comes from someone once praised as a loyal soldier. Even sympathetic media outlets struggled to neutralize its impact, focusing less on disputing the substance and more on attacking the witness's motives, a notable shift reflecting the difficulty of confronting the details directly. Meanwhile, courtroom observers reported that prosecutors appeared confident and energized. After weeks of building a documentary case, they now had a human witness laying out step by step what he saw. The intensity grew further when Trump posted on Truth Social during an afternoon break, calling the witness a rat and a traitor. Legal analysts immediately flagged the risk. Publicly attacking a cooperating witness during trial can be seen as witness intimidation, or, at minimum, demonstrates poor judgment under judicial scrutiny. Once a trusted insider cooperates publicly and survives cross-examination, others may reassess their own exposure. The psychological barrier to cooperation drops. A precedent is set. Politically, the testimony creates a problem that messaging alone may not fix. Abstract legal arguments can be reframed or dismissed as partisan, but first-hand accounts with corroboration are far harder to neutralize. A vivid eyewitness account hits differently. Voters can picture the scene. A former president standing in front of a fireplace, feeding documents into the flames. That image is concrete, memorable, and difficult to counter with slogans or procedural defenses. Republican candidates and party leaders now face a tougher set of questions. Supporting Trump increasingly means defending not just contested legal theories, but sworn testimony from someone once trusted implicitly. That is a heavier lift, especially for figures trying to distance themselves from ongoing legal turmoil. The day ended with a sharp contrast in tone. Prosecutors appeared confident, having finally put a human face on months of documentary evidence. Trump, by contrast, appeared volatile both in court and online. His choice to publicly attack the witness during trial only reinforced legal experts' concerns about judgment and restraint. At the very least, it underscored how personally threatening this testimony is to him. Veteran prosecutors have been blunt. Insider testimony backed by physical evidence is often decisive in federal trials. It provides jurors with a narrative they can follow and a witness whose credibility they can evaluate directly. When that testimony is met with visible rage from the defendant, jurors may interpret the reaction as confirmation rather than contradiction. Taken together, this isn't just one witness or one bad day for the defense. It represents a collapse of the argument that Trump is merely a passive figure misled by subordinates or caught up in bureaucratic confusion. When the alleged conduct is described as personal, deliberate, and observed by someone who knew him best, establishing reasonable doubt becomes far harder. If the testimony holds, it signals something larger. The pattern that has long shielded Trump, loyalty enforced through proximity and intimidation, may finally be cracking under the weight of evidence. The legal system relies on insiders to explain what documents and timelines alone cannot. This is that mechanism functioning as intended. The trial will continue. More witnesses are expected. Trump's behavior remains unpredictable, and the jury is watching not just the evidence, but how the defendant responds when former loyalists recount what they saw. The stakes could hardly be higher, not only for the outcome of this case, but for the broader question of whether power and proximity can still override accountability. Veteran prosecutors have emphasized why testimony like this matters. An insider whose account aligns with physical evidence is often the most powerful tool in a federal case. As one former senior Justice Department official explained, this is the kind of testimony that wins trials. Someone who was present, documented events contemporaneously, and whose story matches the evidence. At the same time, Trump's courtroom behavior may have worsened his position. Jurors often interpret a loss of control as consciousness of guilt, and explosive reactions can inadvertently reinforce the credibility of damaging testimony. All of this brings the case to an inflection point. What began as a contest over documents and intent has become a direct credibility battle between Trump and someone who knew him intimately and says he saw him destroy evidence. This isn't an abstract legal argument. It's a concrete narrative, complete with vivid imagery that jurors can visualize. And once they form that picture, it's extremely hard to erase. The consequences extend far beyond a dramatic day in court. Legal analysts are already describing it as a potential turning point in the trial, with implications for both Trump's immediate legal exposure and his broader political future. Start with the immediate effect. Prosecutors now have eyewitness testimony that Trump personally destroyed documents while investigators were actively seeking them. That directly addresses the core elements of obstruction. Before this testimony, the case was viewed as strong but circumstantial, built on documents, timelines, and inferred intent. After the witness took the stand, several analysts told reporters that the balance shifted. What had been a contest of narratives now includes a first-hand account placing intent and action squarely on Trump. Crucially, the witness emerged from cross-examination largely intact. His plea agreement was transparent, his motives openly acknowledged, and his account supported by contemporaneous notes and physical evidence already in the record. That combination makes dismissal of the testimony unusually difficult. Jurors may be skeptical of cooperators, but skepticism weakens when a witness's story is corroborated, and lying would immediately expose him to severe consequences. The testimony also raises risks beyond the current charges. If Trump personally destroyed documents, it strengthens obstruction allegations. If those documents were classified, additional national security implications emerge. And because the witness testified that this occurred after investigators made their demands clear, prosecutors can argue willfulness, a key element that undercuts many potential defenses. Observers note that prosecutors in other jurisdictions will be watching closely, particularly if the same witness has knowledge relevant to additional investigations. There's also a cascading effect on potential witnesses.